Be seated, please. We'll proceed with the cases in the order in which they appear on the calendar. Andrew Graybar and Lynn Graybar versus Golden Eagle Homes Association. You may proceed.
May it please the court, distinguished opposing counsel, I'm Mallory Horn of the Tallahassee Bar representing the appellates, the Graybars. I'd like to reserve 4 minutes for rebuttal. The fabric of this case is pinioned around Golden Eagle subdivision in the north part of Leon County. It is at least a very desirable subdivision wrapped around beautiful lakes and a country club and gated community. And it was established in 1985 by Killearn Properties, Inc., filing its restrictive covenants. Their exhibits 1 and 3 in the plaintiff's exhibits. About 15 years later, and this is the case, the owner of a neighboring piece of property, witnessing all of the grandeur, that's my words, appended its 140 or so acres to an adopted Golden Eagle Homes Association by filing a restrictive covenant itself, calling itself a developer, and calling the Homeowners Association Golden Eagle Homes Association, which I will call the existing legitimate Homes Association. The issue here, very simply, as to that part, is can a neighboring landowner do that in Florida? So the first step I'd like to take is, what did the neighboring landowner do? It recorded its own restrictive covenants, calling itself a developer, and in the face of and with the knowledge of the earlier covenants establishing Golden Eagle Homes Association, establishing the restrictive covenants, and operating the subdivision for almost 15 years. It recorded its own, called itself the developer. Those are words of art that I'll get to in just a second. It went to its first homeowners meeting, Golden Eagle Homes Association, in the latter part of 2001, where the board denied its presentation, rejected the plat, rejected the restrictive covenants, whereupon the neighboring owner simply backed up 1 week later and recorded another set of almost identical restrictive covenants. It rejected, repudiated the board, filed another set of restrictive covenants, and all of this is absolutely uncontradicted, in fact confirmed by the president of the development company. It backed up, filed another set of restrictive covenants, naming another homes association, changed it a little bit, as the Homeowners Association, created that association by articles of incorporation in the Secretary of State, uncontradicted, and then created a plat, creating Golden Eagle 6, Phase 1, dedicating all of the ways and means in that particular plat to, I'm going to call it, the phony Homeowners Association. That's exactly what it is. That plat is not a part of this case, except incidentally.
They abandoned their original plan of joining the existing association. They abandoned that approach?
The neighbor?
Yes.
No, it was never abandoned. They just went around the existing board. They named a phony association, but they did file it. They filed another set of naming the Homeowners Association the phony name, created a plat dedicating all the roads and ways to that phony association. I'm going to call it that so you won't get confused, because the Golden Eagle Homes Association that was for 15 years is now managed that subdivision and manages it to this day. It created a plat and dedicated all the roads, ways, parks to that phony association. And that situation persists to this day. But that's not the issue. The issue is, can they do that? What determines the answer? The governing documents. Those governing documents are by statute now. This was created after the subdivision was in way. Is the restrictive covenants of the entity creating the subdivision. that entity was Killearn Properties in 1985. And those covenants are my exhibits in plaintiffs 1 and 3. There was amendment number 2, but coincidentally, that's all there is. Those restricted covenants govern. Chapter 720 says they do, and they govern in every case. Construing that said, this is actually a case of first impression, because in Florida, there have been other cases in the country, and I'll get to them, I hope, in just a minute. But the governing documents say that Killearn reserves to itself to annex neighboring property. Now, that was a part of its original domain.
Well, that's my question. Are we really talking about an annexation, or are we talking about two coexisting associations?
No. The second homeowners association, sir, has been abolished. It no longer exists. The original homes association now manages their property and this. So it was just a way to run around, really, the homeowners association that they wanted to adopt. They filed all these, but the plat that they sold all these lots to is still on the public record in Leon County. But of the 3 governing documents, the Articles of Incorporation, I think that's Exhibit 10 or 11 of mine, the statute says that restricted covenants and the homeowners association articles govern. The Articles of Incorporation say that it requires a 2/3 vote to annex and adopt a homeowners association. Chapter 720 says you can't dilute the rights and privileges of lot owners without their vote. So the restricted covenants of Killearn require 2/3 vote to annex, unless you're Killearn, and they're not. And so do the homeowners association require 2/3 vote. It is uncontradicted that there never was a vote involving these homeowners. You just can't do that. Now along came 720. 72301 defines all of the terms here, and it says its purpose was to give sustenance to this homeowners association, to give power to them, to clarify the law. But primarily the purpose was to protect the lot owners. That was the stated purpose of 720. And nobody has given them a vote. The association documents themselves say that they must, but they didn't. There is only one slim piece of paper in this entire record, Your Honors, that even talks about a right in this neighboring developer to annex. The appellees in their brief say that the original declarant, that's Golden Eagle, assigned the right to this appellee. That is not the case. There is no piece of paper in this record that says that. So of all the 3 governing documents, 2 of them specifically require a vote if it wasn't Killearn, and it wasn't. They bought raw land. The testimony is uncontradicted in this case that they bought raw land. They did not assume any debt. Chapter 720 specifically says that the developer is one of 2 things. One, he either created the community or he succeeded to the rights of the one who created the entity and assumed its debt in writing. There is no such document in this record. The statute is clear on its face. So are the restrictive covenants. They concede that in the answer brief. And every item of the law that stacks and holds up this case is violated by this act. And so the representation in the answer brief is incorrect. Finally, I want to say that there's no question in Florida law that the courts deal with restrictive covenants. There is not a Florida case that talks about an adjoining owner just deciding it likes the homeowners association because it's well managed, as is the case here, and it likes the amenities, and it likes the name, which has already become a noted label. But there is a case in Illinois, and it's Fairways versus Shenandoah, and it is on all fours to this proposition. Every one of them. Every element of this case is exactly mirrored in that Shenandoah case, and it is cited in my brief. I will take just a second to, what they said was that the Clarn properties, in this case, I'm applying Shenandoah to this, that the Clarn's right to annex reserved to itself unless somebody gets a 2/3 vote. The only people that could annex any land was Clarn properties. It never did, without a 2/3 vote of the people that are deluded by it. This case on all fours, every one of them.
The declaration said Clarn or its successors or assigns, right?
Well, yeah, but they aren't the successors and assigns. I know they say that in the answer brief, Your Honor, but they simply did not do that. There's not a document. On the examination at the trial, I asked them, do you have any agreement with Clarn? No.
We don't have a transcript of the trial.
Sir? We
do not have the trial transcript.
I did not know you didn't have the transcript. But anyway, if the Fairways case said that the defendants contend that they, as successors and assigns of the Richards Group, are the developers as defined in the Fairway Declaration, thus capable of exercising, and we do not agree. Generally, the purchase of property, and that's all that's involved here. That deed is in the record. That transfers this property. They bought raw land. It was contiguous to this subdivision. They just simply said, we're a developer without any right whatever. I see that my time is going down, and I do want to reserve my time. But this case is public policy in two major particulars in Florida. You take the most grandiose subdivision in Florida, 2 or 3 people that bought 40-acre tracts could call themselves a developer and use the name and use the homeowners association without a vote of the people that are being deluded. There is not one piece of paper that ascribes to these appellees the right to append to this subdivision. Thank you, Your Honor.
Good afternoon. May it please the court, I'm Danny Manassa, and I represent the non-association appellees. Mr. Maloney, who represents the association appellees, and I have agreed that I will utilize 10 minutes of our time. It's very important to note that appellant brought 6 different counts against my clients. He lost on each and every one of those 6 counts. But today, they've only appealed one of those counts. And in this appeal, what you are being asked to do is void restrictive covenants for a unit of Golden Eagle which is nearly fully inhabited by third parties. Moreover, they're asking you to enter an order declaring that Unit 6 really isn't part of Golden Eagle. To understand Golden Eagle, you have to go back further than the restrictive covenants. Clarn Properties, Inc., who I'll refer to as KPI, started the process back in 1974. They submitted in 1974 a DRI, a Development of Regional Impact. And what that DRI showed, and this has been stipulated to in the pretrial order, that Golden Eagle wasn't going to be a simple one-unit subdivision. Rather, it was going to be a multi-united, multi-phased subdivision. Keeping with that accord, when KPI filed its first set of restricted covenants in 1985, KPI put the world on notice that this is just the first unit of Golden Eagle. Under its annexation paragraph, it clearly stated that KPI owned certain contiguous, adjacent property which could be brought into Golden Eagle without a vote. And who did it reserve that right to annex to? Not just KPI. I think we've heard a little bit of a omission. It reserved to KPI, its successors, and assigns. Now, the party stipulated in the pretrial order that this Unit 6 is the very contiguous property that KPI owned. That this Unit 6 was included in the DRI. This isn't a rogue pretender developer who bought farmland and is trying to call it Golden Eagle. This is the very property it's been stipulated to that KPI owned, referred to in its DRI, and referred to in its restrictive covenants, putting the world on notice that it could be brought in simply by recording restricted covenants for that new unit. The party stipulated that KPI owned the property and deeded it to Capital First. The party stipulated this property, Unit 6, was deeded from Capital First to my client. So this position today and in the brief that we're a stranger in the chain of title is perplexing at best. It's been stipulated to that we are successor by deed.
What is your authority for the proposition that the right to annex travels with the deed?
Well, Your Honor, we believe the authority is you have to give restricted covenants their plain meaning. The covenants on their face says that KPI, declarant, reserved for its successors and assigns the right to annex it. The face of the restricted covenant speaks for itself.
Did Killarn Properties convey all lands adjacent to Golden Eagle?
The parties stipulated, well, I don't like the phrase adjacent to Golden Eagle because it was all part of the DRI, which is planned to be Golden Eagle. And the parties stipulated that all property that KPI owned, which was not deeded to third-party lot owners, was deeded as raw land to Capital First, who deeded their raw land to my property, to my client. And moreover, Your Honor, at trial, the trial court heard clear and concise evidence that in addition to being a successor by deed, KPI did an assignment of development rights to Capital First, and Capital First, via a written document in the record referred to in my brief, assigned their development rights to my client. So we get it in addition to being a successor by deed, we get it by the assignment of development rights. And I admit there's a dearth of cases on this point in Florida. And I believe the reason is when restrictive covenants say a developer can annex specific property and reserve this right to its successors and assigns, I don't believe anybody's ever taken the position that their successor and assign cannot annex it. And
all right, so you say Unit 6 has been annexed.
Yes, Your Honor. Back in 2001.
And so that the homeowners in Unit 6, they're on the same footing as the homeowners in the rest of Golden Eagle.
Yes, Your Honor. Each unit has its own set of restrictive covenants. Each unit within Golden Eagle has its own set of restrictive covenants, but they're all governed by the association at Pelley's, Golden Eagle Homes Association and Killarn Lakes Association. There is no other association governing Unit 6. They pay dues to Golden Eagle.
At the same rate as everybody else?
Yes, Your Honor, and we'll cover that under our indispensable parties argument, but that's what's so perplexing about the case. And the Illinois case that was cited by appellant, the Fairways case, actually supports our case. And in that case, what you had was a developer reserved the blanket right to annex property. It didn't specify which property. Later, after it fully developed its development, someone bought a separate and distinct tract of property from the same developer and tried to annex it into the original development. And the court ruled that since the property, the tract number 2 as I call it, wasn't referenced in the original restrictive covenants, it was implicitly excluded. That's the polar opposite of our case. Our property was expressly included.
Well, let me ask you, it seems to me that what perhaps separates you from the appellant's position is whether or not twin action properties, assuming that there is sufficient evidence, documentary otherwise, in the record that it was a successor of Killarn Properties, Inc., must it also be shown that it was a developer?
No, Your Honor, I believe it does not. The restrictive covenants, and again, the law in Florida is we have to give them their plain meaning. It didn't say the future owner had to meet the statutory requirements of a developer. It simply said their successor and assign.
Well, aren't contracts made in contemplation of existing statutes that govern the rights of the parties?
But, Your Honor, the statute in question, 720, was enacted well after the 1984 KPI restrictive covenants. So I believe it wouldn't have any impact. But even if it did, Your Honor, if you look at 720, there is a simple definition of the word developer in the definition clause. There's nothing in Chapter 720 that states the developed property in this Florida X, Y, and Z. It's a definitional page for a statute governing homeowners associations. And this gets us to the more illogical component of this case. Unit 6 was platted in 2001. Appellants concede that as early as 2001, third-party property owners relied on the restricted covenants, bought lots, built homes, and my client spent millions of dollars of infrastructure. This is in 2001. This case wasn't filed until 2003. It's critical to note that no third-party lot owners have been named in this case, and as the count directed to my clients to throw out the restricted covenants, to de-annex Unit 6, the association is not even a defendant. So what they're asking you to do is to remove restricted covenants upon which many people relied upon, to not only buy lots, but to build homes. And it gets us to the point where...
What is the relationship between the plats and the restrictive covenants?
Well, Your Honor, the plat is what the county accepted, allowing my client to go ahead and build their infrastructure and sell individual lots as opposed to raw acreage.
So, I mean, the plat is neither here nor there, right?
Well, Your Honor, they're asking you to enter an order that the plat needs to be thrown out. If you look at count 1 carefully, it clearly states that they're asking you to enter an order stating that my client's lots should be ruled not properly annexed. So by definition, they're asking you to rule that these lots within Golden Eagle are no longer part of Golden Eagle. I don't know what we physically do. Do we wall off the lots? Do we create a black hole where those lots are? They've stipulated that there's people living in Unit 6. What happens to those people when my client's lots next door are no longer part of Golden Eagle? What happens to those people when you strike the restricted covenants? But back to your question, the plat shows what you can physically sell. The covenants are more the rules. Who pays the dues? What are the square footage of the homes and whatnot? And it gets us to another troubling part of the case. One of the appellants actually sat on the association's board of directors in the year 2001, and in that capacity conceded she brought no motion to object to the plat. She brought no motion to stop the development. They sat by idly while tens of millions of dollars were being spent on homes and infrastructures, waited 2 years and filed suit. If that's not the definition of waiver, nothing is.
Are you saying the waiver applies?
Yes, Your Honor.
Isn't there some rather strong language in these documents that suggests that waiver does not apply?
Your Honor, there is a non-waiver clause, but after these third parties have spent millions of dollars, there's a point where equity has to reign over the language of the documents. And we get to another indispensable party. Which entity has the authority to accept, record, and alter plats? Leon County, Florida. It's expressly in Chapter 177. No other entity has the right to modify plats without proper notice to all record title holders. Here,
What is the modification of the plat that they seek?
Well, despite what the brief says, the wherefore clause clearly states they want an order declaring that my client's lots are no longer annexed into Golden Eagle, which is a de facto erasure of lots, removing those lots from Golden Eagle. So these people who have homes in Golden Eagle will now have homes next to them that are deemed not Golden Eagle, free to put mobile homes, farm animals, whatever they deem appropriate, I believe. And that's why these third-party lot owners are indispensable parties. And it gets us to the last point of the restriction.
Just a minute, back up a minute. Where does it, perhaps I missed that language, where does it refer to annexation or de-annexation?
Your Honor, they've appealed their losing count 1 in the wherefore clause, letter B. What it states under B2, the property subjects to the ineffective covenants, and ineffective covenants are defined as the Unit 6 covenants, which are still owned by TAP, which is my client, and Hobbs Brothers, which is my client, were not properly annexed to the Golden Eagle subdivision.
Well, is that the gist of it? I was under the impression that the gist of the action of the count 1 was to declare void the covenants.
Well, that's what counsel says, but I'm stuck with what he sued under, which is count 1 of the complaint. They do want to sue under number 1. It says the ineffective covenants are null and void. And again, it says the ineffective covenants, which are defined in the complaint as the covenants for the entire Unit 6, which means there's someone out there sitting in their home and they're about to lose their restricted covenants. And if they're not materially impacted by that, nobody is. There's no lis pendens warning them about this. They have not been named parties. The association's not even a party to this count. It's clearly fair to join an indispensable party. And I believe there's another reason there's a dearth of case law on this. No one's ever waited 2 years to try to invalidate an existing neighborhood. When the testimony at trial clearly revealed that my client's sins were increasing property values, decreasing density, not increasing density. The appellant had to concede that we changed condominium lots into single-family homes. We increased square footage. The testimony at trial is that my client ended up paying more dues than the previous developer. Which gets us to why are we here today? I really do not have an answer to that question other than the covenants, if you give them their plain meaning, my client clearly had the right as the successor by deed and as the assignee by the agreement in the record to annex this property. And even if they didn't, letting somebody develop a unit and pulling the rug out from under unsuspecting third parties, it's too late and the right folks aren't here, and we're asking you to affirm the trial court's opinion.
Thank you.
Thank you.
May it please the court, my name is Robert Maloney. I represent the Golden Eagle Homes Association and the Killearn Lakes Homes Association. Negotiation over litigation is why my clients stand here before you today. Originally, my clients were sued by the plaintiff's appellants because we didn't bring this action against the developer. However, and I know you don't have the trial transcript in front of you, every allegation made against the associations was addressed at a properly called board meeting. It was talked about, it was discussed, debate was taken. At most times, counsel was consulted, and a decision was made. They made a business decision that it was better to try to negotiate rather than litigate, and they shouldn't be penalized for that. We fully understand that the covenants allow the plaintiff to bring this action because he feels that the developer isn't following the covenants, but that doesn't give him a cause of action against the associations for doing so. They consulted counsel, and because there is a dearth of case law in the state of Florida, there wasn't any precedent to give them that would say that they were going to win one way or the other. So they had to make an economic decision, and they did so. Now, what both the appellant counsel and the appellate counsel did not mention is that the covenants and the plat, at no time are any of these required to be signed off by either associations, Your Honor. We don't get to sign off on them or approve them. All we do is get to enforce them. So we are left with a covenant, a binder full of different sets of covenants, and do the best they can to enforce them. And to put the onus on my clients that they should have brought an action because these particular sets of covenants differed enough from the other different set of covenants, we feel is too strong. We would again ask that you affirm the lower court and find for the both defendant associations. Thank you.
May it please the court, what we're talking about here is construction of documents that are clear, restrictive covenants and the statute, and the Articles of Association. Two of those three require 2/3 vote. No evidence in this record as to any kind of vote. The only paper in this entire file that even speaks of any kind of rights existing in this client, this party, is this little piece of paper that purports between Twin Action Properties and Capital First to convey interest in proxy rights to TAP. And whatever, vaguely, rights exist by virtue of some restrictive covenants. It's Exhibit 30. That is the only document that this party can claim any interest or right. And what we're talking about here is interests of people who lived there before, who owned the Homeowners Association, who had all of these several hundred lots put onto its Homeowners Association without its consent. It's a terrible precedent to set for the rest of Florida and this subdivision. There's an easy way out of this. If you determine that these people were not the developer, and you send this back to the court to handle the negotiation between the Homeowners Association, who under those circumstances would inure to the rights of the developer, who no longer exists. If they're not a developer, their covenants don't exist. That doesn't mean the lots go away. That doesn't change the description of the property. It means that Golden Eagle Homes Association, which has been totally run over, This association simply was just overwhelmed by the power of this lot owner. And every case in this country repudiates their position. They have no claim to any successorship. They keep mentioning that it was Killearn that had the right to annex, and their successors and assigns. They just assume that you know that they are successors and assigns. They don't have a document that connects to Killearn in this record or anywhere except number 30. And I hope you'll look at that, and after looking at it, determine that the law of this state is that restrictive covenants are governing documents concerning subdivisions such as this one, and wrapped all over the state of Florida. The public policy of this state is to protect the lot owners, not the developers, Killearn, or them, the lot owners. And this has run rampant over these, and nobody will be hurt by a simple declaration that this kind of skullduggery does not constitute being a developer, nor give a neighboring lot owner. If you carried that to its ultimate conclusion, you'd have the absurd situation of every neighboring 50-acre subdivision or owner saying, I'm the developer, and appending their acreage to it. You cannot tolerate that. And in the name of justice and in the name of construction of documents according to their meaning, they admit in their brief that these covenants are clear and susceptible of only one interpretation. And that doesn't mean introduce evidence about their intent. They say that I should have done that. If the document's clear, you need to enforce it. And the law here is overwhelming. There is nothing that justifies the affirmance of this case. The judgment itself sought to change my pleadings into a totally new suit and then rule on that. The lower court never even approached the principal questions of this case. Thank you.
Thank you.